So it's my privilege to speak first about who Marissa Garcia is. She is the managing attorney at Gold Law, a trust and estate firm with offices in Ventura and Los Angeles County, where she focuses on all areas of estate planning, probate and trust administration, conservatorships, and trust and probate litigation. Ms. Garcia is a certified specialist by the State Bar of California in estate planning, trust, and probate law. She represents trustees, beneficiaries, and/or heirs in trust and estate litigation matters. She regularly represents private professional fiduciaries and court-supervised trusts, probates, and conservatorships. And since 2016, she has served on the court-appointed counsel panel for Los Angeles County, where she's appointed by the court to represent proposed conservatees in limited and general conservatorships. In 2020, she began serving on the newly established conservatee private counsel panel in Ventura County. She is also currently serving on the board as a co-treasurer for the Women Lawyers of Ventura County. Again, I will say in the future, it would be an amazing thing to have some education for estate planners, fiduciaries, and attorneys in this county. Another reason to become a member and support this kind of work that is it's broad for our coalition. It is my honor to have Marissa speak now.
Morning. Thank you guys for having me. I appreciate the invitation. So today we're going to talk about a couple of different aspects of financial powers of attorney, advanced care planning, digital assets, and a couple other topics. So Terry, am I able to share my screen? Am I set up for that?
Hang on a minute. I will allow you to do that. You should be able to now.
Okay. All right. So we're going to do. Are you guys seeing the slideshow? I think it's
yes.
Okay.
You might want to turn it into slideshow.
Yeah,
though.
that's what I'm going to do. I think I need to move it to the different screen. Sorry about that. Okay, is that working now or no?
Very much.
Okay. All right. So we are going to talk about perils and pearls in advanced care planning. And we'll start here. So one of the topics that we're discussing is going to be the things that maybe you want to do when you are newly 18 or in your early 20s, things that generally are not, everyone doesn't think to do, but it's probably a good idea. So we'll start with the financial part. And financial power of attorney is something that anyone who's over the age of 18, as long as they are legally competent to do so, meaning they have mental capacity, they can appoint an agent to act on their behalf, to sign certain documents, engage in certain transactions that will help provide for the management of their assets or assist in the management of their assets. And then we're going to talk about an advanced healthcare directive, but we'll continue here with the financial power. So for someone who's a younger adult, 18, 19, or even in their early 20s, the power of attorney document will allow that child, essentially, even though they're an adult, to appoint a parent to sign on their behalf. And the important part of a financial power of attorney is that it's effective upon signing rather than incapacity. And this can be important when you have that younger child or younger adult going off to college, they're managing their assets, but maybe they need some help. So maybe you guys, they might need help managing bank accounts, or they have a question with insurance situation. The only way that you as the parent can kind of get involved and help is to have the authority to do so. So for example, I had and I'll try to fill this with hypotheticals or examples so we can make it a little more interesting. But I had a client earlier this year whose daughter was a high functioning autistic individual, and she was going to be moving up north to Santa Clara to go to college. She was not in the category where she would need a conservatorship, but she did need assistance with some basic financial management, perhaps going in and getting the tuition paid or registering for classes, things like that, managing the health insurance application the school provides. And so what we did for her was we prepared financial powers of attorney and advanced healthcare directives. So if she needed help, and the goal was she was going to try it first herself, but if she needed help with managing her bank accounts, that kind of thing, then her parents already had in place that power and they could use it on an as needed basis. And the nice part about the financial power of attorney is that it doesn't take away your child's ability to manage their finances. So you're kind of like a safety net, but they can still take that first role in managing it themselves. And it remains effective during incapacity. So I have a little hypothetical that we're going to go through, but I know most of you already know more about advanced healthcare directives, but I just wanted to, as a reminder, that it's not reserved for clients who are elderly or ill. And in fact, the landmark court cases that we have in this kind of area, the patients or the individuals that were the focus of those cases were both in their mid-20s. The Terry Schiavo case, when she first started or fell into that coma, she was only 26. And same with Nancy Cruzan, that was another auto accident case relating to right to die and end of life care, and she was just age 25. So it's not something that, we kind of default, well, I'm not sick, or I don't need it yet, but it is something that sometimes is relevant for a younger generation of individuals. And as you know, you can appoint someone to make your medical decisions, as well as specify what you want those wishes or instructions to be. And in the medical or hospital scenario, when you're dealing with someone who is over 18, the fact that you are the parent, which I'm sure you guys often hear, that's not necessarily sufficient to have somebody step in and make decisions for that now adult child. So in my hypothetical here, we're gonna say Jane is 19 years old. She's a college student. She lives in an off-campus apartment, and she gets into an auto accident. It's a rather severe accident. She doesn't pass away, but she's now in the hospital, and both of her parents are called to the hospital. So they both show up. The parents are divorced, have a relatively decent communication relationship, but they had joint legal custody, but primary custody went to mom during the child's years of minority. So now the doctor wants to try some sort of surgery or procedure. It's high risk, and the parents are at conflict as to whether or not they should proceed. And the doctor needs someone to sign the consent. So in this scenario, if Jane had that advanced healthcare directive in place, that would certainly designate someone to make those decisions. Then the doctor or the hospital has someone to look to make those decisions. But if she does not have anything in place and the parents can't decide, that's when we have conflict, that's when we have court involvement, and that's when we require, the hospital might require a conservator to be appointed. And we're not necessarily talking about conservatorships today, but when you don't have these kinds of care planning decisions or financial planning documents already in place, the only way to obtain those after someone is injured or incapacitated is going to be through some court orders. So without this care directive, that's what the two parents are looking at. And if anybody has questions or suggestions or want to, we can have it as a discussion, that would be great too. But let's continue this hypothetical so we can kind of focus on the financial part as well, the benefit of having that power of attorney in place. Let's say that the parents finally agree, they're going to do the surgery, and it's not a great outcome. She's made it through, but she's going to be in a skilled nursing. She doesn't necessarily have capacity to manage her medical or financial decisions. So what happens now? The parents in this scenario decide, okay, let's move Jane a little bit closer back to home. We'll put her in a long-term care facility near us. So that's their plan. So what happens to Jane's apartment? Mom goes to the property manager, the landlord says, hey, I need to get into Jane's apartment so we can clean out her stuff. And the property manager says, nope, sorry, you're not on the lease. I'm not going to give you access. I'm not going to let you get her stuff. And by the way, we still have a lease. And she's still responsible for the payments, that kind of thing. So how could have Jane's parents helped? If they had that power of attorney in place that authorizes certain specific transactions, authorizes you to do banking, it authorizes real estate transactions, it authorizes you to deal with personal property. All of these would fall into the authority that advanced healthcare, that agent under the power of attorney would have, so that they can then say, yes, actually, I do have authority to enter, and they can now get access to Jane's apartment. They can pack up her stuff. They can communicate with the landlord to try to work out a deal about breaking the lease and how much they're going to pay, that kind of thing. They now are stepping into Jane's shoes to take care of those things for her. So now they've moved her, because now they did have that power of attorney in place. They've moved her down, and they're setting up stuff for her locally. So she's going to be in a long-term care facility. They're going to need perhaps to get her some Medi-Cal benefits so she can be in that facility. They might need to work with the insurance company. Those are all things that the agent under the power of attorney can do. Let's say that because this was an auto accident, there needs to be, there's a conflict with the auto insurance company and the driver of the other vehicle. And now there needs to be the filing of a personal injury lawsuit. Who's going to step in and initiate that on behalf of Jane, who is the plaintiff in that scenario? Well, her agent under her power of attorney can do that. And they can manage those, that they can work with the insurance and file that lawsuit. There's someone appointed to act on Jane's benefit. So these are all different aspects of the financial power of attorney that would be helpful in this scenario. It's not just limited to a signer on a bank account, which is sometimes what we most commonly think of when we think of that financial power of attorney. So there, it gives you a wide range of powers and things that can be helped in this scenario for an 18-year-old or a young adult or any scenario like that. Does anybody have questions? Want to discuss that? Any thoughts, comments? I know it's a lot of information, but the focus here being that these are all things that you don't want to have to step in to do, but it's so helpful to have it because you're dealing with an emotional situation. I mean, if there was a death, for example, a severe injury, you're dealing with all the logistics. And because that child, Jane, is 18, she's an adult. And so you need to have that authority in place, especially when there's conflicts between the family or if parents are not alive, there's multiple siblings. I had a scenario once where there actually was an estate plan in place for the parents. They had 3 children. They had nominated one of the sons to serve as the advanced care agent. And that son had become estranged from mom and dad for a number of years. And so the other 2 siblings, mom passed away. The other 2 siblings were trying to work with the funeral home and the mortuary to get things situated, but they only wanted the signature of the agent under the Advanced Healthcare Directive. And he was basically MIA. They wouldn't take any instructions from the other 2 kids. He was just non-responsive. And so we did have to go into court and get orders for the next person in line to on that advanced healthcare plan directive to step in, because they couldn't get him to decline. That was the valid document, and he was just non-responsive. So unfortunately, for almost 2 to 3 weeks, mom stayed in the the funeral, in the hospital where they, in the mortuary part or wherever they had her. The cemetery would not accept her without the signature of the advanced healthcare agent. And so on top of the trauma of losing mom, that's what this family had to deal with. And so I bring that example out because not only is it important to have the documents in place, but it's also important to periodically look at them and say, is this still what I want? Are these still the people? Are they alive, my agents that I've selected? Do I still speak to them? Because sometimes we do an estate plan signing here. We give you a nice, pretty binder with your estate plan name embossed on it. You take it home and put it on your shelf, and then nobody looks at it for years until there's been a death. And by that time, relationships and people change. People pass away, people move away, that kind of thing. So I want to emphasize that it's important to make it a mental note to take a look at those every few years or after a life event to kind of see if that still matches your wishes. And your decisions about your own medical care might change also. When you're younger, you might have a more aggressive kind of approach of what you are willing to withstand or what decisions. As you age, your perspective might change. So these are all what we call revocable documents, meaning you can modify them and you can change them as your life circumstances and your wishes change. So let's, if there's any other any comments or questions on that area? No? So then we can go over to talking about digital assets a bit. This has become more and more something that's important. And so we incorporate it here in our estate planning documents, but let's talk about what are digital assets. So that can range for that. Well, in general, it's anything that has financial, personal, or administrative value. And that can be music or movies that you've purchased, photos that you've got saved, in the cloud somewhere, social media accounts, your files and your data on your computer, your devices, email, although not employer provided email, but your personal email, and digital currencies as well. And it's important when we're talking about digital assets as it relates to bank accounts to just keep in mind that the digital asset is the app or the manner in which you access your online banking, for example, but it is not the underlying bank account itself. That is a regular trust asset or an estate asset. So when you're trying to gain access to, for example, online banking to get access to manage the bank accounts as a power of attorney, that kind of thing, you're gaining access to the app, the username and password. That doesn't necessarily encompass all of the assets that are held within that financial institution. examples of other social media accounts that are very common now, like Facebook or Instagram or Twitter, TikTok, all of those. I don't know all of them. I'm sure there's far more out there than my 5 that I can probably name, but those are all part of that as well. And it's gaining access to them. These companies now have certain features where after someone passes away, you can shut the whole thing down, or some companies let you have like a memorial page so that family members and friends can leave a message, and it's kind of memorialized in remembrance of that individual. So who can access your digital assets? Well, if you have your estate plan in place, that could be your agent under your financial power of attorney, your executor, your administrator, your successor trustee of your trust, or if we're in probate, a special administrator can do that. And there are different levels of access. So there's 3 levels of access. A user can set up permissions directly in that digital account. So for example, Facebook lets you designate. I know Apple lets you designate. Google lets you designate. So you can pick someone, even if you don't have an estate plan in place or any powers of attorney or anything like that, you can designate someone to have access to your account. The second tier of where these companies will look is who you have designated within your will or your trust or your power of attorney. And the third level is the terms of service agreement. So that document that we all just scroll right down to the bottom and click, I agree. Somewhere in there might be some language about who the company will allow access to your account or your files if you are incapacitated or passed away. And then each account or each provider has different levels of what they will let you access in terms of whether you have the ability to get the underlying information, or you're only authorized to just terminate the account and close it down. So that's something for each provider. So some best practices relating to digital assets are to keep an inventory of them. When we do our estate plan in our office, we have a document that's part of your trust. It's called Schedule A. And that lists all of your financial assets, your real property, that kind of thing. But what we don't often have are inventory of digital assets. So, okay, I upload my photos to Google Photos or Shutterfly. I have a Bitcoin account here, or I have a Facebook page. You know, all of these things, it is really helpful for someone who steps in to know what they should be looking for, what their sort of to-do list is. And one way you can make it easier for your family who will probably be stepping in is to have that list of accounts they need to look to. And on that same related note is the list of passwords. There are some programs out there that let you save your passwords electronically. There are people that still write it down on pieces of paper. You can, have a computer file or something, and that's up to you. I won't suggest how you do it. I don't want that responsibility, but it is a good idea to have that information handy so that that people know. And one of the things that we find that's so helpful when someone steps in as a power of attorney or they're administering a trust is, and it may not be the best way, but I love it when the child is sitting there and an adult child is saying, yeah, I know my mom's online banking password. And it's like, whew, well, we can still get some bills paid, or we still have the ability to get this done while we transition. So having access is a really helpful idea and way to facilitate that transition for your agents or your family members. And then, of course, in your estate planning documents, you would want to make sure that you are appointing fiduciaries to manage those accounts, and that they have the authority to manage those digital assets. So those are some kind of best practices about digital assets and what they are. Does anyone want to discuss, have questions, feedback?
Oh.
Terry?
Well, this all came about partly because of somebody I know whose daughter died suddenly almost a year ago from an undiagnosed glioblastoma. And she took her to the hospital and went into the ER, and she couldn't go in with her. And that was the last time she saw her conscience. And she died a couple of days later when they removed her from the ventilator. And then all of this began to open up, that they did not have any access to any of their daughter's digital assets. They didn't have access at all. And it caused the pain to go on and on and on. It wasn't just the death of the daughter, but the incurring problems just reinforced all of the pain. So I would say this is so important for us to understand.
Go ahead,
Thank
Andrea.
you.
So what happens in that case, Marissa? What happens if the stuff that you're suggesting gets done doesn't get done?
Sure. So in that scenario, what would have happened is that her family would have to go into probate court. And sometimes when you're looking at a younger individual, they may not necessarily have the assets that would really need to be probated. I mean, maybe they have a bank account with a few $1,000s in it. And there are ways for the family to access those funds without a full probate. We have some small estate affidavits and things. The problem with that, though, is it doesn't designate someone as a personal representative to take care of the administrative side, like terminate the lease on her apartment, or close down utility accounts, things, whatever might be going on in the background. It doesn't appoint somebody. So that's why sometimes you might have to go in and start a probate, even if there aren't any assets, because you need that authority. So you might be appointed as the administrator or the special administrator, so that you can get those things taken care of. And unfortunately, that becomes expensive, right? If you're looking at doing or starting a probate where there are no assets, the attorney fees and costs are going to come out of mom and dad or whoever is starting that probate, because generally the fees and costs are paid from the estate itself based on the value and things like that. But if there aren't assets, but the attorney is still going to need to do and take all of those steps and go to court, you're still going to have to go through the same process. Those fees and costs are now going to come out from mom and dad's finances, or whoever is stepping into that role. Go ahead, Terry.
That's exactly what happened.
Yeah.
And she did have an apartment that they could not end the rent until probate had started and they were named the administrators. They also could not get into her iPhone or any of the accounts, which added to the distress.
Yeah.
So it was, that took a long time to figure out how to get there. And they are not easy to work with, the company. So.
And a lot of times now, and we're going paperless, and it's great for the environment, but it used to be that when I first started, we would say to trustees or agents, we would say, well, that's why checking the mail is so important, because you're going to get the bank statements. You're going to see where mom and dad banked. Maybe they don't come monthly, but these investment accounts, they come quarterly, that kind of thing, and you'll get the statements in the mail. But now that might not be the case. they're gonna get an email that says, okay, your statement is ready and you can access your account. So that idea of having the paper document coming in as a trigger to find out where the assets are, that's not as easy of a thing anymore because they're not getting that mail. So again, the digital assets and especially having that access to email, that's where that can help a lot.
So Marissa, you may have, like everything we do is via email. We don't do mail that way.
Right.
First of all, it's safer. But say that we have a Vanguard account and we not only have a password, we have a voice password. How do you deal with that?
That part, so you would, that's great security, but what you would do if your agent or your trustee had the authority to marshal those digital assets, you're going to need to, they're going to contact Vanguard and they're going to give you like a workaround. They are going to, you're not going to access it access it the same way that you are. They're going to give you access, but in it, there maybe their own profile as power of attorney or trustee, or they set up a separate, they're not going to have to log in the same way that you do. Like we have Face ID or things like that, thumbprints. They'll set them up. So the first time around, or the first few times as you're working through this process, you might have to go into a branch, or you might have to call their customer service and escalate it through their legal department and things like that. It's not necessarily going to be they access using your name, your username and password. So that would be how that kind of thing is worked around. Okay. Other questions about digital assets or anything like that? Before we move on. So then we were just going to talk a little bit about, and some of these we might have covered, but we're going to talk a little bit about estate planning misconceptions. And so some of the myths that we have are, I'm too young, I don't need to worry about this. And as we kind of mentioned already, there are lots of reasons why someone who is over 18, maybe in their 20s, 30s, they still need to do a little bit of care planning. It is not necessarily that you need to be an older, wealthy individual to have a trust in place. Financial documents and powers of attorney, those are all things that everybody will deal with. Taxes, things like that. These are all things that can be helped with these documents. But by a lot of time I see a married couple say, well, I don't need to designate my spouse, but they're my spouse. That's nice, but that doesn't mean that they have the authority to sign your name on all these documents unless they are also your agent under your power of attorney. And so a complete estate plan allows you to take care of all of these aspects. A will is where you'll designate guardians. So perhaps that might be something that's sufficient for somebody who's in their 20s or 30s. Maybe they have young children, but they don't necessarily have assets. That's when we would do a power of attorney, advanced healthcare, and maybe a will. But a will on its own is, without those other aspects, the power of attorney and care directive is not going to be good enough, because the will is only going to kick in when you've passed away. But as we all know, there are lots of circumstances when someone is alive and incapacitated or unable to manage in some other way. That will is not going to do them any good to get some help with managing their bills, things like that. Maybe they need a caregiver in their home, but they're not necessarily able to sign a contract on their own anymore. They don't have that capacity, that level of capacity. That's another great tool for a power of attorney, is someone that can sign these contracts on your behalf. And then estate plans are too expensive. That's another common scenario or complaint. And I don't disagree that they probably are expensive, but they are certainly cheaper than a conservatorship, a probate, any of those circumstances where you're litigating who's going to be in charge of your financial decisions, or even if you're not, and you just have to get a court order to appoint someone, the cost of an estate plan is just a drop in the bucket compared to what you might be paying for, especially like a temporary conservator. If you need to get that immediate court authority to make medical decisions, you're not looking at anything less than $5,000 or $10,000 just to get that retainer and that process going with an attorney. So there are ways that you can, I mean, I'm sure there's attorneys and things that can do payment plans, split up the payments, whatever it is. It's far cheaper for you and your family to get it done when you're able to, rather than having to go into court. Okay. And questions about estate planning or anything in that area? So I think that was probably my last slide that I had. So I'm, that's all I have for today, but we can certainly discuss and answer any questions.
Any questions? Do you want to take down the?
Oh,
your slide,
yes,
or
I
do you-
can
or-
do that.
or
No, I
unless
can do
people
that.
want-
I can, let me see, stop share.
Okay, so Marissa,
Mhm.
that was a lot of information. And I
Yes.
feel like I get the privilege, I'm going to go back and make a recording of this and I get to listen again. So I'm excited about that. A little more understanding. So does anybody have questions going back through this?
I don't have a question. I have a comment that I just think your discussion of the integration of the healthcare directive and the power of attorney for finance is very, very important, because
Yeah.
both of those, whether you're an 18-year-old or an 88-year-old, both of those are very, very important to have done. So I thought that was a great aspect of your presentation.
Thank you, Ken. And I did, maybe a week or two ago, Ken circulated a link to some of us. It was a State Bar article that was kind of like here's helpful advice for your 18-year-olds. And I was disappointed to see that there was nothing in there about this aspect of financial power and advanced care planning. I mean, it was helpful information, but they missed a huge, there's like a gap in the article that I felt could have been discussed, and it would have been very helpful. So
I think this presentation is something that should be shared on a wider basis. Like, it's very, very important. You've covered a lot of ground. Any other comments or questions?
If you don't mind, I know I put something up in the chat that I think is very, very important, just from my own personal experience, that, and I don't think the laws have really changed, is it doesn't matter if you've lived with the person for, for many years, as long as there's not a legal document. If you're not married, it's still not, there's no common law in California. And a lot of people are really shocked when they try and get things done. And it's like, well, there's no documentation, there's no nothing. And I know that I try and take the opportunity when I hear somebody say, oh, that's fine, we've been married for, we've been together for, 15 years. And, that's considered married. And I usually pop in and I said, no, not in the state of California. You really need to look into it, because there are other, legal ramifications that go along with the fact that there's nothing legal saying that, this person can take care of my financial stuff. And even though you've been married, you've been together for 15 years, it's still not considered a marriage in the state of California.
Right.
I have a case right now. It's actually really, really sad, where the couple were together for 50 years. She was white, he's black. And when they first met, it was a big controversy in her family. And so they never formally got married. They had kids, but they were never married. And so she's passed away, and he's not an heir. I mean, they had their joint bank account and things like that, but he's not an heir. And her siblings, there's some kids involved with special needs, but her siblings are involving themselves because he's not the spouse. And so it's really sad that, and he's so devastated that he is not the one that's making these decisions regarding her estate plan and things like that, because they were 50 years. I mean, they shared everything, but legally he doesn't have that authority. So absent going into court and starting some litigation, but that's kind of how it falls. So I agree, it is important, especially in those long-term relationships. And that's one of the things also that's nice about the registered domestic partnership, is that it gives some rights as well to same-sex couples and things like that. Even if you didn't want to go the route of marriage, it just lets you designate somebody to make those decisions for you. So
it is a huge problem. The law simply has not kept up with lifestyles, and it's a disaster that happens daily, many times a day. It's really very sad.
yeah, so
Good discussion. Anybody else?
So my one little suggestion, I have a couple of clients that have done this in the last few years, is they, as their gifts to their children who are getting married or are going away to college or something like that, they are now purchasing these estate plans for them. So it might be a bit much for them, especially after a wedding or whatever it is, to now sit down with a lawyer and do an estate plan. But I would say you should consider or tell your friends that that's a great thing that you can do for your kids. You're not the client, it's still your kids that will meet with the attorney, but that's a gift that you can give to them, and in some part to you, because if you do have to step in, it will make things much easier for you to manage. So you might want to consider a different kind of gift this time.
Interesting idea. Never thought about that, but that is, yeah. Instead of buying them chairs, we could have bought them an estate plan.
It's not quite on the registry yet, but it's,
I do like it. And it introduces a conversation, and that becomes more of a natural thing, is what we want to do. So, wow. So if nobody else has questions or comments, I really would like to thank Marissa for this talk. It was very beneficial, and it will be on our website within the next week, is my plan. And I'm going to talk to you about doing this. We're doing Mount Cross in September, but I would like to do a follow-up with this and reach out to faith communities with this important information. Both of the attorneys' talks are amazing, and I'm glad we've gone that way. And I will remind us that we have a meeting in September at St. John's Camarillo, and that is an opportunity for us to do planning for these types of events and have your voice in there. We had a great event in April where people came together with ideas, and we want to follow through with those ideas. So looking forward to that, and to everybody's participation and getting the message out. So if you did not see people here today who missed a very important meeting, please share that information and remind them there is a meeting in September, and we'll get that information out sooner than later. Thank you for visiting and sharing. And Jazz, you're on the screen, so it makes me think you have something to say.
No, I was just, I unmuted in preparation from a question from you in case you were about to ask me about address or room number. And I'll get those to you later, because later today I tried to call and no one answered. So.
Okay, I appreciate that. And we all do. So on speaking for Ventura County Coalition for Compassionate Care, I do appreciate your time today and for sharing this information. And we will see you in a month in person.
Thank you.
Thank you.